right now you have $200,000.
$200,000? And that enrages me. I'm willing to call mutual combat since we can't settle it on paper.
Welcome back to the Van Balian channel, guys. Yes, we are back with the Eddie Banks circus. You know, the guy who threatened to kidnap a judge recently.
If I have to come up in here with men myself to take custody of you, I will. Because you will not use the people's power to step on my life and the people of this county.
And more recently, where he said this to a judge he is in front of today on his way out of court.
Right, you have any last words?
You next? All right.
No, I mean before I go. Honestly, I would like to go.
Do you understand how something like that could be construed incredibly inappropriately?
Oh, now you're offended?
It's not about being offended. This is about your well-being. There are officers here right now.
You sat up there and threatened me.
Mr. Banksell, you said, do you have any last words?
Before I go.
All right. Thank you. We'll see you back here in November.
No, you won't.
Well, today he ramps up the stupid even more in Everett Municipal Court, Washington, by challenging the female prosecutor to mutual combat during yet another one of his status hearings regarding a competency evaluation, which leads to the judge revoking his bail and Eddie doing a runner from the courtroom. No, I am not kidding. Right, let's get into the video.
This is the Eddie Banksell matter. And 3A0225485. Mr. Banksell, you want to come forward?
You really wish to engage me?
Yes, I do. You come grab a seat, or you want to be welcome to stand up. Or come sit close to the mic.
No. See, this is a arena of honorable men.
You keep using that word honourable. I do not think it means what you think it means, Eddie. The moment the judge or the prosecutor say something you don't like, you threaten them with violence.
So, if y'all can run y'all court the way you wish, allow me the same respect, and everything is copacetic.
All right. This is the Eddie Banks matter, Eddie Banksell matter, 3A0225485. This was on, there was previously a competency evaluation ordered. There was some non-compliance with that, but ultimately, most recently on December 4th, a new out-of-custody competency evaluation was ordered, and that's the last status that I have set for today to check in on status. Any status regarding the out-of-custody competency evaluation?
The court knows it takes up to a year, so we're still waiting for an out-of-custody evaluation. I believe he has it in jail, and then we're going to do it in custody. One bailed out, so here we are. You're going to talk to me today?
Months out of custody for the evaluation. It's restoration that can take over a year.
Well, I mean, I guess the real question is, I don't have anything to file that comes or that gives any sort of status update. I'll also note in this case there was previously an out-of-custody evaluation that was ordered, and for example, the letter came indicating that Mr. Banksell hadn't attended that.
What's your name?
First time, so this is the subsequent order. I haven't seen anything indicating that it was scheduled and hasn't been attended or anything to that effect. So does anybody have any information about any status?
I have not been contacted again by Western State, but that takes even longer than the evaluation. So I have no information about when that would happen. This was to be done in November, so we're not even close to a year.
Well, just as another indication for another case, it looks like the order entered in October, and that evaluation happened right at the end of January. So for this one, that would have put us about 3 months out. So we're possibly looking at in the next 6 weeks or so that it might be a date, but not a course of just based on that timeline. city regarding the evaluation?
No, Your Honor. Generally, the orders request that defense counsel schedule them because they have the ability to communicate with their clients about the evaluation. We'd ask that this case be continued for Mr. Banks to have his scheduled evaluation. And so far, with the last order being entered in December, it should probably, like I said, be set forward 6-7 weeks.
All right. Anything to add, Mr. Smith?
And I've been assigned as Mr. Elbank's attorney, but it still doesn't talk.
All right. Well, Mr. Banksell, what we're looking at is the evaluation hasn't been done yet. You know, last time we talked about court ordered, and the preference was for you to do it out of custody instead of in custody. We're still in that same.
What don't you understand about free will and free sanctity of mind?
Well, I understand that. We've talked about this before, that you're ordered to do the evaluation. You have a couple of options. You can do it out of custody or you can do it in custody. And you agreed last time you got out of custody. Is there a change to that agreement?
Yeah, there have been changes.
Okay.
After you finish doing what you're doing, so
I'm done.
you're done?
Yes.
So is it my turn?
You're welcome to go.
Okay, welcome to go. All right, I'm giving notice of case number 24-201-08931. Since you don't want to listen to me, Honorable, you don't want to listen to documents, I have here a statement that's been published. Oh, can I give copies? My bad. I don't want to scare y'all because I'm an honorable man. I'm not trying to hurt anybody. Letting my political will be known. You don't have any interest, and I'm not a beneficiary to these proceedings. You just want to tap into my blood and my resources and drain me. I'm not accepting it. So I've instituted civil proceedings against you. Now, Miss Megan, I would like to get her name. You should be served within a week. I'm gonna add him, add her. Y'all don't want to listen?
Did you do this last time?
No. This has been public.
No?
Yeah, this is something new.
Yes, as you heard there from Eddie's counsel, he has done this before. Eddie, unsurprisingly, has a long history of filing indecipherable and incoherent frivolous lawsuits going back years. I'm talking 12 years or so, that have all been dismissed for failure to make a claim. So I'm sure the judge and prosecutor are shaking in their boots right now. Just Google Eddie Alexander Banks lawsuits.
So can I give you all a copy?
I'll defer to you when you're okay with
There you go. Summons. Oh, it's public. It's not a problem for the city and for yourself. All right. So the next step, if you want to continue, what I'll do is every state official who wishes to continue, when I bring this federal matter, there will be no excuses, no reliance on, I didn't know, I didn't understand. You tried to this man's individual free will. I'm not having it. So that's all I have to say. You can continue as you please, but I'm telling you, you're not free from the consequences.
So, Mr. Banksell.
No, I'm pretty much finished, but I'll be respectful.
It still leaves us where we're at before. I understand if you want to bring proceedings, you have a right to do that, right? But where it leaves us still is you're ordered to do this competency evaluation.
No one has the authority to order me to do anything.
Well,
For what reason? What proof?
Ah, there it is, the "you're not the boss of me" defence, which always works out so well for these guys. Seriously, you need to change the record and drop that persecution complex because this is embarrassing. Also, I find it absolutely hilarious listening to you talk about consequences when all this is about you not accepting the consequences of your own actions. But what's new with these guys?
So the court's ordered it. It's there in a court order. And again, the situation that you're in is you have to either engage in that out of custody, which you agreed to last time, or what we can do is find that you're not compliant with the conditions of release, amend the bail order, and then you'll have to engage in that evaluation in custody. It is still one moment, it is still very much my preference that you engage that out of custody. I don't think that there's any reason that you need to be in custody to do the evaluation. But one of the reasons that you would have to do it in custody is if you refuse to do it out of custody.
Tell me, why do I have to see your people for an evaluation?
Well, that's something, a conversation you can have with Mr. Smith, and we talked a little bit about.
No, it has to be.
One moment, Mr. Banks, I'll give you a chance. So, you have the right to present evidence about the competency, the status of competency if there's a disagreement about the report. You have to engage in the evaluation that's been ordered.
Okay, so who's here to compel you to perform according to my trust res?
Well, if you're asking about who else could assist you in getting an alternative evaluation,
No. I'll do this. I'll do this.
About that last time.
Yeah. I forgot. I've filed this too. Let me make this a part
I
of
think
it.
that's already been, I can kind of see it from here. I think that's already been filed in the court. So, let me.
No, not this. You know what it is?
Well, I see the seal, so I guess it looks a little bit.
Yeah, because my court runs on the same seal that your. No, that's not the same.
All right. You can bring it up.
This is a choice of law, living trust law. Nah, I just created that, buddy.
Well, it's great for me.
Okay. Only the flag and the seal. So we're going to see. Because we're going to enforce contracts. You want to enforce yours on me? We're going to see. We're going to see if the Republic and the law is real.
Well, first of all, you've been getting owned by the law for years now, so if anyone knows how real it is, it's you. And secondly, how cute is it that you have your own court, flag and seal, complete with red thumbprint? Just don't go around pretending any of that stuff has any authority to arrest people and or lock them up somewhere, because that's when the real law will come down on your ass.
All right. So, Mr. Banksell, the decision that we're talking about today, you're ordered to engage in the out-of-custody evaluation. One second. What we're looking at is, I haven't had any information, and you remember what this was like. I assume you remember what this was like several months ago, that the evaluation wasn't engaged in, and the conditions of bail were met. Recall that?
Keep creating evidence against yourself, man. It's fine.
All right. Well, certainly all of that's in the court record. Whether you want to agree with recalling those events or not. But we're at the position where if we're going to do that again, then the conditions of release simply need to be amended and you need to be back in custody so you're engaging that evaluation.
Okay.
Last time we were here, you agreed under what you described as duress.
Okay.
That you would engage in that evaluation out of custody. And I want to make sure you're still on that same page, that you're agreeing, although it's something you don't want to do, and you're...
And it's going to be public. The evaluation has to be public. Because I don't trust you private individuals, because look at what you're doing.
So, Mr. Smith, part of that order is he can engage in the evaluation and be there, and then really that's between however that evaluation goes between, one second, between you, between Mr. Smith, and it's between the evaluator. So that's something I can't make a decision about whether it's public or not. This is your private information. So you're going to have to leave it up to the evaluator. If you want to somehow publicize this or have somebody looking at it, that's your decision in combination with the evaluator, okay?
It's my turn now?
Yep.
Okay. So, again, I need to assess why it has to be your people, because I've experienced this before. I've already had one independent, and you are rejecting that. So tell me why this specifically has to be your people. Because hold on. Because your person can tell me to my face and write down this and that and the third, and then report and say, oh, he's suffering from psychotic disorder, NOS, not otherwise specified, yada, yada, yada. So that's the problem. So if we can get an independent party, then yeah, I will consider it. But No, I'm not seeing your people.
So if your last independent evaluation concluded that you are in fact, and these are your words, psychotic, then I can understand you wanting another independent evaluation and then another until you eventually get the evaluation you desire. Unfortunately, the judge is in charge and can determine who you see. And it looks like the Washington State Healthcare will be performing the evaluation, whether you like it or not.
You said that you were going to get your own private evaluation.
And I provided it for the
You were
court.
going to use that instead, and the court said that was fine, but you haven't done that yet.
What do you mean? I provided the proof.
Proof of what?
Mental evaluation.
When?
The last time we were in court. You don't have it
I
now?
wanted a new one.
Who wanted a new one?
You need one that's contemporary. A couple of things. One is, you talked before about some of the other experiences you had. I want to be clear again that this is not any sort of restoration evaluation. It's not sending any sort of order of restoration. It's not any order that requires medication. Nothing about a blood draw, anything like that.
Can you give me 48 hours to inspect all paperwork, all contracts that is supporting the transaction?
One second. Let me finish and we'll get back to that. And all this is speaking with somebody. So there's no treatment, no medication, nothing. Okay, so I want to be clear about this evaluation. The authority is the statute that provides that Washington State Health Services can provide these evaluations by court order. You are welcome to submit one. Dr. Smith has talked to you about that. Court files in public. I think in the past, gone to the court, got files or copies of the files. They're all there. Where I'm left is something that you just said, is you will not engage in this evaluation whatsoever.
Because I don't have a reason why. Why?
Because you're ordered to do it out of custody.
Who has the order? Tell me what reason, what authority does that?
Mr. Banksell. This is.
That's all you have to tell me is where the authority comes from.
Mr. Banksell has gone over this. If you'd like to copy that out of custody order, that order to evaluation, I can give you that. And it goes over the The problem is, if we leave here, or not leave here, if we can't get to the point where you agree that you'll engage, even if it's under duress and something that you don't want to do in this out of custody evaluation, the only option that I have is to amend the conditions of release, set bail, and then you'll engage in it in custody.
I've already given my declaration of political separation. You're free to do whatever. Notice has been put in the living trust for protection with the Sheriff's Department, with the U.S. Marshals, and the Police Department. So that makes their departments liable. So whatever orders, paperwork you want to push through, if they want to put themselves on the line to defend you, then so be it. But I have made my will as a man. I'm a reasonable man, non-violent. I don't talk.
I'm a reasonable, non-violent man, says the guy who, in the last 3 months alone, has threatened to kidnap a female judge. Threatened this judge by asking him if he had any last words, and now is about to challenge the female prosecutor to mutual combat.
But what you're trying to do, what you're doing to compel me to do something that I do not wish to do as an ordinary man, that's unacceptable, man. That enrages me. I'm willing to call mutual combat since we can't settle it on paper. Let's settle it like men.
All right, this is your final opportunity.
Well, first of all, if being held accountable for your actions, i.e. trespassing, enrages you that much, you've got serious problems, mate. And secondly, if you're capable of challenging a female prosecutor to a fight in a courtroom full of people, then I pity and I'm concerned for anyone unfortunate enough to live in the same house as you.
Are you going to engage in the out-of-custody evaluation as ordered?
My political will has been made known publicly.
What's the current conditions of release at?
Go ahead, man. Do your will. Oh, I'll stay and get it on because this is live on Facebook anyway. We're going to see.
All right. Yeah, please. So I'm going to call We have an officer here. I'm amending the conditions for bail.
Man.
Previously ordered.
I'm gone. I'm
Bail
gone.
is going to be forfeited.
I'm gone.
And I'm setting bail right now in the amount of $200,000.
$200,000. Wow.
Yes, $200,000 bail is steep, I'll grant you that, but it shows just how done this judge is with this guy's shenanigans. Let's just hope law enforcement slap the cuffs on him before he has the chance to flee the courtroom. I think I spoiled this one in the intro.
Mr. Banksell, you've had the opportunity to engage in this out-of-custody evaluation multiple times. You're not following the conditions.
So you're going to strong. Okay.
I'm setting bail in the amount. Your bail is...
Nah. See.
Mr. Banksell, the opportunity is over, unfortunately. Your bail, your bond is being forfeited.
All right.
It's being set in the amount of $200,000.
Yeah. Well, that's a crime. That's for the public. Hey.
Welcome to stay here.
No, sir. You've been served a summons. If you go and do that, come on. I'm ready to go, man. I'm ready to go. I ain't playing that shit. $200,000. $200,000 to have me. That's one of them right there. Look at her. She was on the case too. Fucking fraud. $200,000 gonna put me in jail. All right. Fuck that.
Right, so that's where the live stream ends. I guess there were no law enforcement available at that time to take him into custody for whatever reason. And I guess they still haven't caught up with him because at the time of this recording, his Facebook account is still active. But his bail was amended to $200,000 and he was ordered to have an in-custody competency evaluation. So it's only a matter of time. Right, thank you so much for watching, guys. If you enjoyed the video, please leave me a like, share the video and subscribe to the channel. Thank you also to my channel members and patrons for your continued support. I really appreciate it. And if you would like to support me and get early access to videos like this, then the links to do all that are in the description. Right, take care all, and I will catch up with you in the next video.